Okay, guys, welcome back to the next session. This session is about how to solve case law. How to solve case law in your corporate law paper is ఏంట how to law case law, how to solve case law in your corporate law paper. So the case law is like this. So many paragraphs, almost you see some four, five, six paragraphs you have, then there later on some three, four questions they will be giving you, and each question will be carrying 2 marks. So the first important thing, whenever case law question is given like this, my sincere advice first, some case laws questions can be answered without reading the case law. Simple logic. You look at the questions first. If you look at the question here, there is section 76A. If you know section 76A without reading even case law, you can answer. But you have to read the case law. I'm not saying you should not read the case law. First, you read the question and look at the section. Immediately, you will start thinking about the section. Then go and read the paragraph. You can easily answer. Next, very important, says question number one, may again section 77. Section 73 to 76. Section 73 to 76 are related to deposits. Okay, so 77 to 87 are related to registration of charges. Understood? That is one thing. So the next important thing is they're also asking about something called section 103. The moment you think about section 103, you should think about quorum. 103 quorum. So you should know these sections, relevant sections, first of all, you should know. So the moment you read randomly, when you read the question, you will understand what exactly are the sections that are given in the case law. So that is why I'm telling you from the beginning, do not listen to anyone. Please have a grip on the sections because it's CA course. It's not going to be easy course. With 45 marks without writing sections, you won't clear this exam unless and until in other subjects you got very good marks. That is why I've been insisting on every CA inter student or professional students, when you write law, as better as you can, please mention the sections. And if you know the section only, you will know the concept. That is very, very important. So now first step is what? First, randomly find out the number of sections that are involved. Then try to think about what are those sections, what is the concept of those sections. Look at this. So I gave from this case law, I picked up some section 76. What section 76 is it? It says eligible public companies only. Eligible public company only can raise deposits from the public. That means private company cannot raise money from the public. That too, all public companies also cannot raise money from public in the form of deposits. If in case a public company wants to raise money from the public in the form of deposit, it has to be eligible. To be eligible, net worth turnover criteria you have to follow. Net worth turnover criteria you have to follow. You got my net worth turnover criteria, and special resolution has to be filed with ROC. You got my point? That is one thing. So that is one thing. Then credit rating, etc. You have to do. Then 76A says, 76A is there in the question. It talks about penalties, severe penalties for companies who contravenes deposit section 73 to 76. So section 73 in this talks about deposits raised from the members. Section 76 talks about deposits raised from public by eligible public company. Section 76A says if in case you violated 73 where company can raise money from member, 76 where company can raise money from public, then penalties is a companies face fines between 1 crore to 10 crore, while officers also will face up to 7 years imprisonment and fines from 25 lakhs to 2 crores. That means company is being punished and officer is also being punished. Usually this kind of questions they won't ask in case law questions where descriptive answers to be given. 99% this kind of what you call sections you will get only in MCQ penalties. Then 76 says punishment for contravention of chapter 6, that is charges. Chapter 5 is chapter 6 is charges. Charges section will start from section 77 to 87. Section 77 to 87. It says, as per the latest amendment, if a company violates this provision, that means chapter 6 provisions, if you violate, that is charges provisions, if you violate, whether non-registration, registration, etc. It says company penalty is 5 lakhs, and while defaulting officers will be paying a penalty of 50,000 rupees. Over here also 86 also says the company and the officers will be liable to pay penalty. 876A says if you violate deposit section, that means, see carefully, In one case law, they're asking almost three chapters, 73 to 76 deposit chapter, 77 to 87 charges chapter. And again, 96 to 122 is 96 section to 122 in company law is related to meetings, general meetings. Understood. 77 says it is the duty of company to register charge whenever company happen to borrow money if the company has shown security or created a charge on the security. Creating a charge on the security is nothing but giving interest on the property, in the sense giving rights and benefits on the property to the lender. Understood. So we have some stories there in 77. You have to register within 30 days, otherwise plus 30 days, otherwise plus another 60 days. Overall 120 days today. But before 2018, rules were different. Before 2018, rules were, if in case you want to register even after the prescribed term, then you have to apply to central government in form charge 8. So that story comes here. I'm not getting into that story. I'm just highlighting the section. So section 77 insists on company to register charge whichever it is created within 30 days. Next, section 103. See, section 103 is related to meetings again. This is where I'm telling you the sections in company law are game changer, because the moment you write the sections, I'm telling you, you will understand the concept. Then concept is written carefully, some marks will be full. Because I'm not designing all these things. I'm telling you, you might be thinking, oh, Mr. Raipudi is designing all the. No, I'm going according to ICA textbook only, ICA model papers only. Courtesy to ICA Institute. Yes, I'm not creating anything. Not only me, nobody can create anything. Everybody has to follow ICI. Everybody has to follow ICI. Everybody. Only thing is, I'm interpreting being a teacher. That's it. I'm only interpreting because everything is there in the book. You won't be able to follow, but I'm interpreting. Teacher job is to interpret. So I'm making it more clear. That's it. 103 says quorum, right? What is the quorum? If a private company, two members in person. So that means proxy is not counted. If it is public company, up to 1,000 shareholders, five. Up to 5,000 shareholders, 15 members in person is a quorum. More than 5,000 shareholders in a public company, if you have 30 members in person, is a quorum. So section 103 says if a quorum is not present within half an hour from the date, from the time of starting, then chairman uncle will adjourn the meeting to the next week, same day, same time, same agenda. This section further clarifies that if in case next week, if there is any change, if there is any date change or venue change, etc., you will have to send 3 days notice before next week meeting. And it also says in the next week, if in case again quorum is not present, whoever is present is quorum. Whoever is present is quorum. That's what this section says. If adjourned meeting lacks the quorum, the members present, even if they are fewer than the required number, that is usually two less than, also constitute valid quorum. That is for private company. Private company, two members in person. If less than one member is present, also it's quorum. In where? Adjourn meeting. So first of all, whenever you read the case law, first of all, you need to understand what are the concepts and which chapter is involved. That is why when I teach in my class, I always tell students, boss, this is how bunch, like chapter 1, chapter 2, chapter 3, like chapter 1, all the definitions you have in your company law, like chapter 2, you have section 3 to almost 23. Yes, 22, right? Chapter 3 stops 23 to 43, 42. Then for like this in a bunch, in a scheme, if you remember sections, then the moment you read the case law, you will understand, okay, this chapter is related to that, this concept is related to so and so concept, so and so chapter, so and so sections. Automatically you'll remember. That is what you have to do. You don't take it like I'm reiterating again and again. Module 1 CA Inter, if you do not score 60 in corporate law, I'm telling you, you will definitely face problem in your aggregate. Because there is every chance to score 60 marks above in law, corporate law, because 30 marks MCQ is there. Concept clarity like this, if you have, you can easily manage. Because MCQs, you're not supposed to lose. If you lose MCQ, that means you just studied and understood law, but not according to the provisions. Because the nearest options will be given, you will get confused. Then first step is read the questions and see what sections are involved. Then you will understand what concept is involved in the case law overall. Then automatically your mind start giving you the sections which are associated with that particular chapter. Then go to case law and start reading fast. You should develop a reading style, the fast reading style. So even if you read fast, you will be able to understand case law because you already read the questions and you came to a conclusion what sections are involved, what chapters are involved. Automatically, you will have a clarity. Got my point? So this is how you have to have. Now, after understanding the sections, after immediately thinking about the sections, go to the case law. Takata, go to case law. See there, I'm reading fast. Sunset Private Limited, a private company. First of all, he's saying it's a private company. And the company faced severe cash constraints. These are all general information to consume your time. Some of the paragraphs are there. That is why if you read the question, you will know what to skip in the case study, right? If you did not read the questions, you will end up reading every line and you will get confused. You will consume a lot of time. Then overall time management is a big issue, right? Had you read the questions before reading the case law, you know exactly what to pick from the case law, right? Because you already read the questions briefly. See, the Mr. Ramesh advanced 25 lakhs to the company. He orally stated that money came from his personal account but did not provide a written declaration. Okay. The company also circulated. This is all not related to our questions at all. That's why I'm reading very fast. Then on 25th April 2024, the company also circulated notice inviting deposits from the public. Deva, what is the problem here? What is this Sunset Private Limited? It's a private limited company and they want to raise money in the form of deposits from the public. No, only Section 76 clarifies only eligible public company that satisfies turnover net worth criteria and special resolution criteria can raise money from the public in the form of deposits. What nonsense is this? Immediately you have to come to a conclusion. That is what is the grip. That is why some students will clear in 3 attempts, 4 attempts, because the students consistently preparing, has been preparing. When they have been preparing, what happens? Then the clarity increases, right? No, in Jaldi, in just 6 months only, I want to become CA in 1 year. Topa, only 10% of the students, they will clear CA in 1 attempt. First, you understand and respect that. You understand and respect that first. Respect this course first. It is a difficult course. Examiner is expecting something. Examiner is expecting your concept clarity, expert knowledge, and it takes time. Some of you might not get it immediately. So therefore, respect the process and prepare for 3, 4 attempts. No. You want to have big salaries in future and you don't want to spend some, you don't want to show patience, you don't want to show consistency. How is it possible? And see, one more problem. Company did not appoint even trustee. First of all, it's a private company. They were and company did not. So this total first paragraph is not at all useful to you for the questions that are given. See, check if you carefully you check if you want. Okay, now quickly move on. In 2024, borrowed 2 crores from the Horizon Bank, created a mortgage. This is related to your question because charges is whenever company happen to borrow money, company has to create a charge on the assets, mobile or immovable, and the charge that is created from that date of creation within 30 days, it has to get registered with ROC. So see that this point is company never filed particulars of charge to ROC. And later on default occurred, repayments, etc. During liquidation, depositors filed claims that so and so money has to be given and security has to be sold and give money. Liquidator will say, hey, your charge is not registered. Unregistered charge. So for unregistered charge, penalty is there, no? Section 86 may. See how they wasted almost your 5 minutes or through 4 to 5 minutes time just making you read the paragraphs which are not connected to the questions which are given, but only second paragraph is connected. So penalty for not registering. Immediately you should think 77 to 87 charges related. Tuck. If you remember one by one, then you will understand what exactly is the section 86 or what exactly is the punishment given in charges lesson. Meanwhile, the company had fixed the annual general meeting. Annual general meeting, again, one more concept started. See that now, third line, one shareholder attended within half an hour. One shareholder, so chairman uncle nicely adjourned the meeting. Again, in adjourned meeting, also one shareholder, automatically section 103 should come up here. Here, section 77 and 86 should come up here. That is what the grip you have. Why students are failing in law, though they understood law, because they are not following the structure, they're not saving the time when they're writing the exam. This is not a course where simply they tick mark and pass you. No, they read every line. They're not worried about your grammar, English grammar, but they are worried about your concept. Seriously. Understood? So here it is about quorum. Next one, parallel. So because you see, why am I coming to a conclusion quorum related? Because I've already read the question. Something is related. Some question is related to quorum. In parallel, what happens? A group of minority shareholders allege that invitation of deposit was disguised attempt by the directors, etc. And the company deliberately failed to comply deposit related provisions. That means company 76A will come, deposit related provision 73 to 76. 76 automatically comes here. Seeking disqualification of directors, the tribunal was also approached to determine whether resolutions passed in the adjourned meeting are correct or not. How adjourned meeting resolutions will be correct? Because there was no, the resolutions at the adjourned meeting will be correct. The reason being, 100%, the reason being what? One member present also is quorum, right? Now, relevant or irrelevant, you have to filter like this. The creditors argued that such resolution could stand in law, could not stand in law, whereas the directors maintained that they followed. Yes, in adjourned meeting, whoever is present is quorum. That's what we understood. Okay, next. Adding to these complications, ministry initiated prosecution against the company, default in repayment of deposits. So default in repayment, at the same time, register imposed penalties under section 86 for non-registration of charge. So two sections are coming here. 76A, the penalties for violating deposits. Section 86 talks about penalties for not registering, registration. 86 is very simple section. But generally, when you're reading that lesson, 86 is very simple. So we may ignore it. But see, now case law is created. It's a January 2026 question paper, boss. So do not ignore any section. Sometimes you say, oh, section 22 is just authentication of document. Oh, I can ignore her and Aina. Like this, they will create. Like this, they will create. Be careful. Now answer the first question. What is the first question? The default of sunset deposits raised from public, etc. Section 76 will result in both company and every officer. So he is not asking how much to be penalized in the option. He is only asking whether company alone will be penalized or every officer will be penalized. Every officer will be penalized. So I gave a section below. Okay, next, for failure to register of charge. Understood? The effect under section 7. The charge is void. Why? Because you did not get it registered. Then against the liquidator means what? At the time of winding up, liquidator will not give priority to such creditor whose charge is not registered. It says even creditors. See, so in the case law, what they're asking, boss, we need our money. You sell the security and pay us. But the law says what? 86 section clearly says what? If company failed to register, that is void. The charge created is void against the liquidator, against the creditors also cannot touch the security, and liquidator also cannot use that security and clear the debts. First, he will clear the debts of others whose charges are registered, along with officers liable for penalty. Understood? Next, third question. In the adjourned meeting, also same thing happened. One shareholder attended and resolutions were passed. The validity of such resolution will be determined by whom? Section 103, not the company. It provides that members present at the adjourned meeting form quorum, even if one member present. Each question carries 2 marks, 6 marks. Trust me, if you have a grip aane ke liye some time will be taking place. I'm telling you, you will definitely take some time. It is not possible for 100% of the students to have a grip on the concepts unless you follow the method which your teachers are guiding you. Follow the teachers, that's why. When they say don't take this subject as theory subjects. So please work like this. Now that I gave you some idea how to answer this kind of case law, 2 case law questions you may have, or 2-3 case law questions. I mean, especially for MCQ related, make sure you follow this. First, read the questions and check. The moment you read the questions, you will understand what concept is associated. Then immediately start reading and analyzing sections and start ticking off the, because answering the question is very easy because it's an MCQ. Here, MCQ questions. Got it now? All the very best. Please subscribe this channel and share this information to your friends also, whoever is writing CA Inter exams. Thank